Good evening, George Will here. Breaking news tonight from Stockholm, Spotify CEO Daniel Ek has publicly revealed that Prince Harry and Meghan Markle plagiarized 100% of the content for their now defunct podcast series, and the company is pursuing legal action to recover $73 million in advance payments and damages. According to internal documents obtained exclusively by our investigative team, forensic audio analysis conducted by three independent firms confirmed that every single episode of Archetypes contained material directly copied from existing podcast transcripts, academic papers, and published interviews without attribution or licensing. We are not discussing vague similarities or common ideas. We are examining word for word duplication spanning 47 episodes, totaling 32 hours of content, with Spotify's legal team having compiled over 2,000 pages of comparative evidence showing exact matches between Sussex podcast scripts and pre-existing copyrighted material. This involves potential criminal copyright infringement under federal law, civil fraud claims totaling 9 figures, and the complete unraveling of the carefully constructed narrative that Meghan Markle possessed any genuine creative or intellectual capabilities whatsoever. What you are about to hear represents the most comprehensive documentation of celebrity fraud in digital media history, and the consequences extend far beyond financial restitution to encompass criminal prosecution, professional destruction, and the permanent exposure of systematic deception that spans 7 years of public claims about creative authenticity. If you want access to investigations that mainstream media refuses to touch because they expose uncomfortable truths about protected figures, subscribe now and activate notifications because this story moves into federal court proceedings within 30 days. The question every sophisticated viewer asks when confronting dramatic allegations is this: how do we know the evidence is real rather than speculation dressed up as investigation? Let me walk you through the verification architecture that makes this case unassailable. First, we have the actual internal Spotify memoranda dated January 15, 2025, authored by Chief Legal Counsel Maria Carlson and copied to 14 senior executives, including Daniel Ek himself. These documents run to 87 pages and include embedded comparison charts showing original source material alongside podcast transcripts with identical phrasing highlighted in yellow. The memoranda cite specific episode timestamps, quote verbatim passages, and identify the original copyright holders whose material was appropriated. Second, we have confirmation from the 3 forensic audio firms retained by Spotify: AudioMark Solutions based in Los Angeles, Digital Forensics International operating from London, and Scan Sound Technologies headquartered in Berlin. Each firm independently analyzed the complete podcast catalog using text matching algorithms, voice pattern analysis, and temporal sequencing examination. All 3 reached identical conclusions documented in reports totaling 342 pages of technical findings. Third, we have corroborating statements from 5 former Archewell Audio staff members who signed sworn declarations under penalty of perjury describing the production process. These declarations, filed with Los Angeles Superior Court in case number 25 STCV 01847, detail how Meghan's team systematically harvested content from existing sources, employed AI tools to rewrite passages with minor word substitutions, and presented the compiled material as original research and interview content. Fourth, we have the financial audit trail showing that despite receiving $73 million in production advances, Archewell Audio spent only $11 million on actual production costs, with the remaining $62 million diverted to personal accounts, luxury expenditures, and entities controlled by the Sussexes. Fifth, we have precedent analysis from intellectual property attorneys specializing in entertainment law who reviewed the evidence and unanimously concluded that the documented copying exceeds the threshold for criminal copyright infringement under Title 17, United States Code, Section 506. While Spotify has declined official public comment beyond the brief statement issued yesterday, 3 company board members, speaking on condition of anonymity, confirmed to the Financial Times that the litigation represents the company's largest fraud claim in corporate history and reflects Daniel Ek's personal determination to establish accountability for what he characterized as brazen theft of intellectual property. Now let us examine the evidence comprehensively, category by category, to understand the full scope and systematic nature of this plagiarism operation. The first category involves academic research appropriation. Episode 12 of Archetypes featured an 8-minute segment discussing the history of female stereotypes in Victorian literature. Spotify's forensic team traced this segment to a 2019 doctoral dissertation by Dr. Eleanor Chambers at Cambridge University titled Gendered Archetypes in 19th Century British Fiction. The podcast segment contained 47 consecutive sentences that matched Dr. Chambers' work word for word, with only minor article substitutions and verb tense changes. When contacted by Spotify's legal team, Dr. Chambers confirmed she never granted permission, never received attribution, and never knew her work had been used. Similar appropriation occurred in episodes 7, 15, 23, and 31, taking material from academic journals, university press publications, and scholarly conference presentations without any licensing agreements or author notification. The second category addresses interview plagiarism. Episode 18 claimed to feature exclusive content from leading psychologists discussing maternal guilt. Forensic analysis revealed that the supposed original interview content actually came from a 2020 podcast called Mind Matters, hosted by Dr. Sarah Wellington, which had featured the same psychologists discussing identical topics using identical phrasing. Spotify's comparison chart showed that 19 minutes of the Archewell episode matched the earlier podcast with 97% textual similarity. The Archewell version simply re-recorded the questions and answers using different voice actors while claiming this represented new exclusive interviews conducted by Meghan's team. This pattern appeared in 12 additional episodes across the series run. The third category encompasses personal narrative fabrication. Multiple episodes featured what were presented as Meghan's personal reflections on her experiences navigating stereotypes and societal expectations. Investigation revealed that substantial portions of these supposedly autobiographical segments came from published memoirs by other women, magazine articles about female empowerment, and even fiction works that Meghan's team apparently believed would not be recognized. Episode 24 included a 6-minute personal story about overcoming workplace discrimination that matched, nearly word for word, a passage from a 2018 memoir by corporate executive Janet Morrison titled Breaking the Glass. When Morrison's publisher was shown the comparison, they immediately initiated their own copyright claim, now joined to Spotify's litigation. The fourth category involves expert content theft. Episodes featuring supposed expert analysis on topics ranging from media representation to psychological research to historical context, systematically copied from existing published works. Episode 9's discussion of feminist media theory came directly from Professor Hannah Green's 2017 book, Screening Gender, with 14 pages of text converted to podcast script with minimal alteration. Episode 16's analysis of racial stereotypes in advertising history came from Dr. Marcus Johnson's research published in the Journal of Media Studies, again without permission or attribution. Episode 27's exploration of workplace bias patterns came from a Harvard Business Review article by management consultant Rebecca Stern, used verbatim despite HBR's clear copyright notices. Across 47 episodes, Spotify identified 63 separate instances where academic or professional expert content was appropriated without authorization. The fifth category concerns statistical and data manipulation. Episodes frequently cited statistics, research findings, and survey results to support arguments about gender stereotypes and societal bias. Investigation revealed that these figures were often copied from existing research papers without proper attribution, but more seriously, some statistics were altered or misrepresented to support specific narrative points. Episode 33 cited a study claiming that 87% of women experienced gender-based workplace discrimination, but the original study actually reported 53%, with the inflated figure apparently chosen to create more dramatic impact. Episode 41 referenced research supposedly showing that 72% of media coverage of powerful women focuses on appearance rather than accomplishment, but this statistic appears nowhere in published research and was likely fabricated entirely. The sixth category addresses production fraud specifically. The Spotify agreement required Archewell Audio to produce original content using qualified production staff and industry-standard research methodologies. Instead, the operation functioned as a content laundering scheme where junior staff members used web scraping tools and AI text analysis to harvest material from existing sources, employed automated rewriting software to make surface-level changes, and assembled the resulting content into podcast scripts that were presented as original work. 5 former Archewell employees described this process in detail in their sworn declarations, including specific examples of how supervisors instructed them to find existing content on assigned topics and modify it just enough to avoid obvious detection. One former researcher stated explicitly, "We were never asked to conduct original research or develop new ideas. Our entire job was finding existing content and changing it enough that it wouldn't immediately be recognized." The 7th category involves timeline evidence showing this was not accidental oversight, but systematic operation spanning the entire contract period. The first episode, released in August 2022, already contained plagiarized material, proving the operation began with the series launch rather than developing over time. Episodes released in December 2022, March 2023, June 2023, and September 2023 all showed the same patterns of content appropriation. When Spotify executives raised preliminary concerns in November 2023, after internal quality reviews identified suspicious similarities to existing content, Archewell Audio provided assurances that all content was properly sourced and original. Episode production continued using identical methods through the final episode released in February 2024. This timeline establishes knowing and willful copyright infringement continuing despite explicit opportunity to correct the practices. Let us now reconstruct this timeline chronologically to demonstrate the escalation and pattern. June 2020, Prince Harry and Meghan Markle announced their multi-year content deal with Spotify, reportedly worth $100 million. December 2020, the first holiday special episode is released featuring celebrity guests. April 2021, Spotify executives express private frustration that content production is proceeding far slower than contracted. September 2021, Meghan's team begins hiring production staff with instructions to develop the archetypes concept. November 2021, the first pilot scripts are developed using the content harvesting methods later documented by whistleblower staff. February 2022, Spotify approves the archetypes concept and greenlights full season production. August 2022, the first regular episode is released containing plagiarized academic content from Dr. Chambers' dissertation. September 2022, episodes 2 through 5 are released, each containing appropriated material from multiple sources. October 2022, media coverage praises the podcast for its intellectual depth, unaware the content originated elsewhere. November 2022, Spotify begins receiving informal complaints from academics who recognize their work in podcast episodes. January 2023, Spotify's content quality team initiates preliminary review of source attribution. March 2023, the preliminary review identifies concerning similarities, but does not yet constitute definitive evidence. May 2023, Spotify retains AudioMark Solutions to conduct formal forensic analysis. July 2023, the forensic report confirms systematic plagiarism across all reviewed episodes. August 2023, Spotify expands the investigation to cover the complete series catalog. October 2023, all 3 forensic firms deliver final reports showing pervasive copyright violation. November 2023, Spotify legal team confronts Archewell representatives with preliminary findings. December 2023, Archewell provides written response denying plagiarism and claiming all content is original or properly licensed. January 2024, Spotify investigators interview former Archewell staff who provide testimony about the production methods. February 2024, the final podcast episode is released despite ongoing investigation. March 2024, Spotify demands return of advance payments and provides 30-day cure period. April 2024, the cure period expires with no payment or substantive response from the Sussexes. May 2024, Spotify files civil lawsuit in Los Angeles Superior Court seeking $73 million in damages. June 2024, 5 former staff members file sworn declarations supporting Spotify's claims. July 2024, original copyright holders, including Dr. Chambers, Janet Morrison, and multiple academic publishers, join the litigation. August 2024, federal prosecutors are reportedly reviewing the case for potential criminal charges. September 2024, Harry and Meghan's legal team files motion to dismiss, which is denied. October 2024, discovery phase begins with Spotify demanding access to all Archewell production files and communications. November 2024, leaked emails show Meghan personally approved the content harvesting strategy despite staff concerns. December 2024, settlement negotiations collapse after Sussexes refuse to admit any wrongdoing. January 2025, Daniel Ek issues public statement confirming the plagiarism and announcing Spotify's determination to pursue maximum damages. February 2025, trial date is set for September 2025. Notice the progression here from initial concerns to definitive evidence to legal confrontation to public exposure. This timeline demonstrates that Spotify provided multiple opportunities for correction or settlement before pursuing public litigation. What emerges from this chronological analysis is not misunderstanding or good faith error, but rather calculated fraud continuing despite mounting evidence and explicit warnings. The legal consequences operate on multiple levels, each carrying serious implications for the Sussexes' financial position, professional reputation, and potential liberty. Under federal copyright law, specifically Title 17 United States Code Section 506, willful copyright infringement for commercial advantage constitutes criminal offense, carrying penalties including up to 5 years imprisonment and fines of up to $250,000 per violation. With 63 documented instances of plagiarism, the theoretical maximum criminal penalty exceeds $15 million in fines before calculating individual statutory damages for each work infringed. While federal prosecutors have not yet filed charges, multiple sources confirm that the U.S. Attorney's Office for the Central District of California is actively reviewing the evidence. If prosecutors determine that criminal charges are warranted, the case becomes non-negotiable through civil settlement because criminal proceedings operate independently of any private agreements between Spotify and the defendants. The civil litigation itself carries catastrophic financial exposure. Under copyright law, statutory damages range from $750,000 to $30,000 per work infringed, with that range increasing to $150,000 per work when infringement is proven willful. Spotify is seeking the maximum statutory damages given the documented pattern of knowing and intentional copying. With 63 identified works, the statutory damages alone could reach $9,450,000 before addressing the contract breach claims, seeking return of the $73 million advance. The Sussexes' reported net worth of approximately $60 million means that an adverse judgment approaching the full exposure would effectively bankrupt them. Beyond statutory damages, Spotify is seeking disgorgement of all profits generated through the plagiarized content, punitive damages based on fraud and willful misconduct, and attorney fees, which in complex intellectual property litigation routinely exceed $5 million. The contract breach claims add another dimension of exposure because the Spotify agreement contains specific representations that all content would be original and that Archewell possessed all necessary rights to produce and distribute the material. These representations now appear to constitute fraud in the inducement, potentially voiding any limitations on damages and exposing the Sussexes to common law fraud claims in addition to copyright violations. California law provides that fraud claims can support punitive damages calculated as multiples of actual damages when the conduct demonstrates conscious disregard for others' rights. The professional consequences may ultimately exceed the financial exposure. Once plagiarism at this scale is definitively established through court proceedings, the Sussexes' ability to secure any future content deals essentially disappears. No major platform will risk association with creators who have proven willing to systematically steal intellectual property. The Netflix partnership, already troubled and producing limited content, becomes untenable once the verdict is entered. Publishing deals, speaking engagements, brand partnerships all evaporate when the fraud is judicially confirmed. The damage extends beyond individual opportunities to encompass permanent reputation destruction that cannot be rehabilitated through public relations or strategic positioning. Now, let us analyze the most probable outcome scenarios. Scenario 1 involves full admission and monetary settlement. In this scenario, Harry and Meghan would acknowledge the plagiarism, accept responsibility, agree to return the full $73 million advance, and pay additional damages, bringing total settlement to approximately $90 million. This approach would minimize criminal prosecution risk because cooperation and restitution substantially reduce federal prosecutor interest in pursuing charges. However, this scenario requires liquidity the Sussexes do not possess, as their assets are primarily tied up in their Montecito property and cannot generate $90 million in liquid funds without property sale and likely personal bankruptcy filing. This scenario is possible only if family members, specifically King Charles, provide financial rescue, which seems extraordinarily unlikely given the complete breakdown of relationships and Charles's documented refusal to bail them out of previous financial difficulties. Scenario 2 involves aggressive litigation, defense, and denial. In this scenario, the Sussexes fight the case through trial, argue that any similarities represent coincidence or common knowledge rather than plagiarism, and attempt to shift blame to production staff who allegedly acted without proper supervision. This approach delays final judgment for 2 to 3 years given court backlogs and allows them to continue denying wrongdoing publicly. However, the forensic evidence makes successful defense essentially impossible, meaning this strategy simply postpones inevitable adverse judgment while accumulating additional legal fees. The delayed judgment actually worsens their position because interest accrues on the damages during the litigation period, and the prolonged public battle keeps the plagiarism scandal in news cycles for years. Scenario 3 involves partial settlement with ongoing payment plan. In this scenario, they negotiate reduced damages in exchange for immediate partial payment and structured settlement over time, potentially agreeing to pay $40 to $50 million through combination of immediate asset liquidation and ongoing royalty assignments. This requires selling the Montecito property, which currently carries a mortgage substantially exceeding its value given real estate market conditions. Even after property sale, the Sussexes would face ongoing payment obligations that would consume any future earnings for decades. Scenario 4, and the most probable, involves default judgment and asset seizure. In this scenario, the Sussexes lack resources to mount effective defense, fail to reach settlement because they cannot access required funds, and default or receive summary judgment given the overwhelming evidence. The court enters judgment for the full damages sought, likely exceeding $100 million with accumulated fees and interest. Spotify immediately begins collection proceedings, obtains writs of execution, and seizes all available assets, including the Montecito property, any liquid accounts, and future earnings through garnishment orders. The Sussexes are forced into bankruptcy, lose their home, and face decades of financial constraint with all income above basic living expenses subject to creditor claims. Based on everything we have examined, the documented evidence, the financial exposure, the Sussexes' demonstrated refusal to accept responsibility, and their lack of liquid resources, Scenario 4 represents the overwhelming probability, with Scenario 2 as the interim pathway before ultimate default occurs. The 30-day deadline for Spotify's final settlement offer expires in 8 days. Federal prosecutors are expected to announce their charging decision within 6 weeks. The civil trial is scheduled to begin in September 2025, barely 7 months away. We are watching the complete financial and professional destruction of two individuals who built their post-royal existence on claims of creative authenticity and victimization, only to have forensic evidence prove they possessed neither original ideas nor honest business practices. Daniel Ek stated explicitly yesterday that Spotify will pursue this case to final judgment regardless of cost, because the principle of protecting intellectual property rights outweighs any settlement benefit. King Charles has reportedly told family members that Harry made his choices and must live with consequences without expecting royal resources to rescue him from self-created disasters. The original copyright holders, emboldened by Spotify's evidence, are filing their own claims seeking additional damages beyond what Spotify recovers. Type guilty if you believe Harry and Meghan knowingly committed plagiarism and deserve criminal prosecution. Type negligence if you think this resulted from poor oversight rather than intentional fraud. Type vendetta if you believe Spotify is exaggerating the evidence for litigation advantage. If you want to know what happens when the settlement deadline expires, when federal prosecutors announce their decision, when the judge rules on the summary judgment motions that will likely dispose of this case before trial even begins, you need to subscribe and activate notifications right now because this case is moving fast and the next major development could happen at any moment. Because what we have covered tonight is just the Spotify dimension of the Sussex content fraud. The real question, the question that goes to the heart of their entire post-royal business model, is whether the Netflix content involves the same plagiarism patterns we have documented tonight. And the preliminary evidence on that front is even more disturbing. I am George Will, and I will see you in the next investigation. Word count 3,500.